Hello everyone and welcome to this video. So my name is Danica Gabriel Ruado, and for this episode we will be talking about chapter 1 of obligations and contract. So Article 1156 states that an obligation is a juridical necessity to give, to do, or not to do. So this definition is not comprehensive. It does not say who should do what, or who should do the giving or receiving, okay? So, first, let us define obligation. Obligation is a legal relation established between one party and another, whereby the latter is bound to the fulfillment of a prestation which the former may demand of him. So, we have different elements of obligation. First, we have an active subject, which is also called as the obligee or the creditor. We have a passive subject, who is the obligor or the debtor. We have the object or prestation, which is the subject matter of an obligation and may consist of giving a thing, doing or not doing a certain act. And then the officiant cause or the vinculum or the juridical tie. Okay? So please do remember that. So we have kinds of obligation according to subject matter. We call it the real obligation, which is the obligation to give, and the personal obligation, which is the obligation to do or not to do. Now, let's talk about natural obligations. Natural obligation is not being based on positive law, but on equity and natural law. So, do not grant a right of action to enforce their performance, but voluntary fulfillment by the obligor. They authorize the retention of what has been delivered or rendered by reason thereof. So, when we say natural obligation, it's more of moral, okay? Moral in its sense and character. So, it's voluntarily, okay? The keyword here is it's more of moral and voluntary. Okay? The juridical relation created by virtue of certain facts between two or more persons, whereby one of them, known as the creditor or obligee, may demand of the other, known as the debtor or obligor, a definite prestation. Okay. So the elements are, as I said earlier, we have active subject, passive subject, object, prestation, and efficient cause or juridical tie. The requisites of prestation are: it must be physically or legally possible, it is determinate or determinable, and it has a possible equivalent in money. So we have different sources of obligation. We have the law, the contracts, quasi-contracts, acts or omissions punishable by law, and quasi-delic. The sources are exclusive. So, Supreme Court said in Sagrado Orden de Predicadores versus Nacoco, declared the occupant's obligation to pay rentals, like any other obligation, must arise from law, contract, quasi-contract, crime, or negligence. If occupant took possession of the property with the permission of the alien property custodian without any express or implied agreement between them, that rentals would be paid for the use and occupation of the enemy property. None may be recovered by pre-war owner. Next, Article 1158. So it states that obligations arising from law are never presumed. Hence, in cases of doubt, presumption is against the existence of an obligation arising from a particular law. So never presume an obligation. No agreement is necessary before obligation or ex lege can arise. Example, one who gambles and wins can be compelled by loser to return the winnings, as stated in Article 2014. So, action is called indebitatus assumpsit. Sit. Okay? Then, we have different types of innominate contracts. We have do ut des, which says, I give that you may give. Do ut fascias, I give that you may do. Fascio ut des, I do that you may give. And fascio ut fascias, I do that you may do. In Pelayo versus Lauren, this liability to support originates from the mutual obligation which the law has expressly established between the married couple within the meaning of the law. The father and the mother-in-law are strangers with respect to the obligation that devolves upon the husband to provide support of medical assistance to his wife. It does not appear that the contract existed between the defendants and plaintiff physician. So this Pelayo versus Lauren is a very good story um, determining who has the obligation to pay. So in this story, actually, in this case, um, the physician, okay, did his job in delivering the child. However, the physician was not paid. So, since the person who called the physician was the mother-in-law and the father-in-law of this person, the physician was asking for payment from the mother and the father-in-law. However, the jurisprudence stated that um, mother and the parents-in-law does not have obligation to the physician to pay. The only person who would have the obligation would be the husband. Okay? Okay, next. 1159. Obligations arising from contracts have the force of law between the contracting parties and should be compiled with in good faith. Okay? Except those contrary to law, morals, public custom, public policy, and public order. So in Article 1159, this is more of contracts. Okay, so we have different types of contracts that we'll be discussing later on. One good case also would be Perez versus Pomar, wherein it stated that it does not appear that any written contract was entered into between the parties for the employment for the plaintiff as interpreter, or that any other innominate contract was entered into. But whether the plaintiff's services were solicited or whether they were offered to the defendant for his assistance, inasmuch as these services were accepted and made use of by the latter, we must consider that there was a tacit and mutual consent as to the rendition of the services. So this gives rise to the obligation upon the person benefited by the services to make compensation thereof, since the bilateral obligation to render service as interpreter on the one hand and the other to pay for services rendered is thereby incurred. So, an innominate contract of fascio ut des was implicitly established. Okay? The obligations arising from this contract are reciprocal. And apart from the general provisions which respects contracts and obligations, the special provisions concerning contracts for lease of services are applicable by analogy. Um, it's also good if you would have time to read Maritime Company of the Philippines versus Reparations Commission, because here the rule is that the law forms part of and is read into every contract unless clearly excluded therefrom in those cases where such exclusion is allowed. So now we are talking about the sources of the law, ha. So this is the first source of the law is the contract. Okay. So you can also read Cuy versus Arellano. This is about a scholarship which was awarded in recognition of merit and to help students in whom society has established interest or first lien, and not to keep outstanding students in school, to bolster prestige and increase its business and potential. So it's a very good case, and I hope that you really read it. Okay? Obligations arising from contract need not always be expressed like those from law. So they may be implied. Oh, this is one of my favorite notes here, because sometimes people usually think that when we say contract, it needs to be written or it has to have a signature. But actually, the law recognizes implied consent. Okay. or implied contracts. Yeah. So here in Aldaba versus Court of Appeals, the issue was there a contract whether express or implied? The ruling was no express agreement to pay for the services rendered. So no implied contract also because petitioner did not expect to be paid for the services. When a person does not expect to be paid for his service, there cannot be a contract implied, in fact, to make compensation for said services. Now, to give rise to an implied contract to pay services, they must have been rendered by one party in expectation that the other party would pay for them and accepted by the other party with knowledge of the expectation. So, as you can see, it states that there needs to be knowledge of both parties. Okay. So another source of law is the quasi-contract. So it arises from lawful, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched. Okay. So an example would be Article 2154, which is you have to return money paid by mistake. Okay. So kinds of quasi-contract. First, we have negortium gestio, and second, we have solutio indebiti. So let us discuss negortium gestio. So this is Article 2144 to 2153. So it's the voluntary management of the property or affairs of another without the knowledge or consent of the latter. While solutio indebiti, on Article 2154 to 2163, is a juridical relation which is created when something is received, when there is no right to demand it, and it was unduly delivered by mistake. Okay? So that is negortium gestio and solutio indebiti. In negortium gestio, okay, let us further discuss. Because this is a quasi-contract. Okay. In negortium gestio, for example, since it's a voluntary management of the property or affairs of another without the knowledge or consent of the latter, this does not apply when property or business is not neglected, in which case provisions on unauthorized contracts shall govern. And as well as it does not apply when the manager has been tacitly authorized by the owner, in which the case the rules on agency shall govern. Okay? Now, in solutio indebiti, the general presumption is that money paid by one to another was due to latter. So you have to remember that. Okay. So the requisites of negortium gestio is gestor must voluntarily assume agency or management. Business or property must be neglected or abandoned. Agency or management must not be authorized by owner, either expressly or impliedly. And assumption or of agency management must be in good faith. So for example, X abandoned his fish pond in Marawi. He fled to Manila. Y, seeing fish in the pond for harvest, took possession, harvested fish, and sold the harvest to Z. When Y borrowed money from W to buy supplies of fish fry and prepare fish pond for next crop. So, issue. Is there a juridical relationship between X and Y? So, Y is the gestor and X is the owner or beneficiary. And then there is an officious manager. Obligation of Y to X as regards to contract of Z. Y must account of his operations and deliver to X price of harvested fish. Okay. Obligation of X as regards to Y's contract with W. X must pay loan to W. X must answer for obligations incurred with third persons in his interest. And legal effect of X expressly ratifies Y's management. Shall express agency and X is liable to pay commissions habitually received by gestor. Okay. While the requisites of solutio indebiti is that there must be payment, the person who made the payment was under no obligation to do so, and the payment was made by mistake. Okay. So, that is our chapter 1. Okay. Now, so we talked about contracts, quasi-contract. Actually, there's a lot more. Okay. Aside from that, we also have delic. And then we have quasi-delic. So, you can read 1161 in delic. It states that civil obligations arising from criminal offenses shall be governed by the penal laws subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2 Preliminary Title on Human Relations and Title 18 of this book regarding damages. So, we can also check Article 1162, which is quasi-delicts, which states that obligations from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. So, quasi-delict, it's a fault or act of negligence or omission of care which causes damages to another. There being no pre-existing contractual relations between the parties, there must be an act or omission by the defendant, a fault or negligence by the defendant, damage caused to the plaintiff, direct relation or connection of cause and effect between the first and the third that I've mentioned, and no pre-existing contractual relations between the parties. So, those are the requisites of a quasi-delict. So, that ends our discussion for Chapter 1 of Obligations and Contract. So, stay tuned for the next chapter.